Namaste and greetings. I, Ritika Pandey, researcher at IMPRI Impact and Policy Research Institute, प्रभाव एवं नीति अनुसंधान संस्था नई दिल्ली, extend my warmest welcome to you all to IMPRI Web Policy Learning. Today we are gathered here for day 5 of the LPPYF Law and Public Youth Fellowship Cohort 3.0. The theme for this cohort is Advancing Justice, Bridging Gaps in Public Policy Enforcement. We welcome you to join us for an immersive journey into impactful policy and action. The chair for the program is Professor Vibhuti Patel ji, visiting distinguished professor IMPRI. The lead advisor and legal hands-on sessions will be dealt by Advocate Dr. Shalu Nigam ji, visiting senior fellow IMPRI, advocate, author, and researcher, gender and human rights. Our expert for the panel for the program includes Advocate Dr. Albertina Almeida ji, lawyer and human rights activist, Goa, visiting senior fellow, IMPRI. The conveyors for this course are Dr. Ajay Guruvarthi ji, Advocate Selena Thomas ji, Dr. Simi Mehta ji, and Dr. Arjun Kumar ji. Proceeding further, we welcome everyone to this transformative journey and appreciate your dedication in investing your time, energy, and commitment to gaining a profound understanding of this crucial role and intricate details of policy and action. We have also shared course outline and reading resources in your email for your kind perusal. Before we start today's session, I would like to state the housekeeping announcements. Please join the meeting on time. There will be question and answer session after each presentation. Share your questions on the question and answer box. The questions must not be posted as an anonymous attendee. Ensure that your questions are precise. Refrain from making general comments in the question to save time. To begin today's session, I would like to invite our chair, Professor Vibhuti Patel ji, visiting distinguished professor, IMPRI, to give her opening remarks. We welcome you, ma'am, and over to you.
Thank you, Ritika Pandey, for introducing the course. Today, we are on day 5 of the course, and we'll begin with the thanking Dr. Arjun Kumar, Dr. Simi Mehta, Dr. Ajay Gudavarti ji, and our lead advisor, Dr. Shalu Nigam, for their hard work in putting this course together. And we welcome today's expert, Advocate Albertina Almeida, for the session on operationalizing constitutional framework in public policy enforcement, and Advocate Shalu Nigam's legal hands-on session 4. The brief overview of what all has transpired so far. Day 1 began with Sri Shailesh Gandhi's presentation on accelerating time-bound justice. He also told about the delays. He said the delayed justice is equal to injustice, and he gave so many examples of how various people from different sections of marginalized sections, they are suffering because of no speedy justice. Indian prisons, he said, had over 78% prisoners are under trial who languish without getting any access to justice. After that, we had Mr. Sandeep Chachra, who also was there in the inaugural session, who talked about the question of how the NGOs and his organization Action Aid made a very important decision of creating people's agenda based on grassroots level experiences, in which they visited 300 districts and 18.5 lakh people they met, and through 51,000 meetings over a period of 1 year. The various branches of Action Aid did that. Day 2, we had Dr. Shalu Nigam, who introduced the participants to the current concerns in human rights discourses with example of the question of hunger or income inequality, plight of millions of crores of gig workers, and colonization of whole entire market by the big corporates, and the human miseries that are the resultant of this kind of greed for very capitalistic profiteering. After that, we had Dr. Vaida Nayanar's presentation on the question of democracy, and it was immediately after the election. So, largest event of democracy was concluded with the 18th Lok Sabha election, and she went into the comparative analysis of democratic governance in Scandinavian countries, in Western world, in Canada, USA, Australia, and all these different examples, how the democracy gets operationalized, while in India it is a directly elected representatives who have a legislative power. And she also said that some of the dangerous trends which are emerging because of majoritarianism also subsumes the rights of minorities, about which we need to be very conscious about, and we should use other instruments for such as United Nations and creating a public opinion in favor of democratic rights of minorities. After that, we had a Professor Sina Paul's presentation on research paper writing, and she gave a 10-step model of writing a research paper, starting from title and abstract and introduction and review of literature and various types of inquiries that we can have of research methodology, ideology, and the research methods, and discussion, limitation, and future scope, and how to do the referencing. Day 3, we had Dr. Shalu Nigam's legal hands-on, very important subject of access to justice, free legal aid to empower poor and marginalized. She delineated the step-by-step and the details of Legal Service Authority Act in 1987 and how it has been operationalized at a national level, at a district level, and at a block level. And also she talked about the Lok Adalat, where the forum, which is a forum for disputes and cases which are pending in a court for a long time, how do they get a platform for hearing, and what are the limits, to what extent Lok Adalat has mandated power to settle disputes. She also mentioned India Justice Reports 2019, 2020, 2022, sponsored by Tata Trust, and she also talked about the democracy deficit, and she said the civil society efforts of use of our right to information, dignity and rights of people, gender-based violence, rights of differently abled people, right to life and food, how it gets connected to the right to food, and also the question of peace, which she discussed. And she ended with a quotation from Justice Bhagwati about judicial activism. Day 4, means the previous session that we had was by Mr. Himanshu Shekhar, a veteran journalist who covers the parliamentary debates. He spoke on the pillars of democracy, institutions, and practice from media lens, and he gave ample examples of his personal involvement in covering some of the very, very controversial issues such as disaster and climate change and pollution and air quality, heat wave, abnormal weather, and the volatile debates that we had and the polarization of public opinions that we had, and how as a journalist you have to maintain your ethics and see to it that all parties get represented. After that, we had Advocate Lara Jisani's presentation on climate change and environmental justice and current policy changes, where she focused on a dilution of environmental standards and made a very elaborate and exhaustive presentation on contemporary crisis of global warming, excess use of fossil fuel, destructive development activities, CO2 emission, greenhouse effects. And she said that gave a whole history right from the colonial times till the present, that how forest laws have been tweaked to subserve the interest of the corporates at the cost of the communities which are inhabitants and the communities which are affected, and the pathos and the human miseries which are created by this kind of environmental standards dilution. Then Dr. Shalu Nigam, in her legal hands-on third session, she spoke on death penalty, and we had a very interesting debate on death penalty. And she also said that some 870 nation states have already abolished death penalty. India is continuing it, and worldwide abolition is necessary for enhancement of human dignity and progressive development of human rights. And today now we are on day 5, and we are going to have again a very, very interesting discussion on constitution and public policy. Thank you.
Thank you, ma'am, for walking us through the introduction of this program. Now, I'm delighted to invite Advocate Dr. Albertina Almeida G for her session on operationalizing constitutional framework in public policy enforcement. Over to you, ma'am.
Thank you. It's my pleasure to interact with the participants of this Youth Fellowship Cohort 3. So basically, the reason we are talking about operationalizing constitutional framework in public policy is because the Constitution of India is a vibrant living document. There is a certain basic structure in the Constitution which is not to be touched. It's like the basic framework of our existence as a country and as a people, and for the existence of our as a country and a people. But the Constitution has broad precepts there, the broad concepts embodied in it, and so it is necessary to operationalize them, because since they are worded broadly and society is evolving, so many new developments are taking place, like technological developments. There are, like you have been discussing in the earlier days, there are issues about climate change. There are issues of competing interests, and various other concerns that are emerging. And therefore, in a sense, the Constitution is so widely worded that it can encapsulate and speak to the evolving situations. It might require some amendments here and there, but basically it can speak to the evolving situation within the way it is worded. But because it is also so widely worded, it needs, so that people will not have to go to court and say, look, this is my right, I need some kind of a entitlement based on this provision in the Constitution. So there, for that reason, there are laws. Now, since these laws are there, sometimes what happens is the laws are, or rules and regulations, or they are crafted in a way that they operationalize the Constitution in those laws for whatever the purpose of that law. Say if there's a law on disability, or a law on sexual harassment, or a law on domestic violence, or a law on right to information. So the laws operationalize those constitutional principles. But sometimes it also happens that in the name of operationalizing the constitutional principles, there is a shutdown on the fundamental rights. So then we have a system where we have legislature, executive, and judiciary, which act as checks and balances to each other. So therefore, the judiciary can act as a check and balance on the legislature or on administrative action. Then we can also ensure that as a democracy, because it's the legislature, we can make demands. We have also the situation where we have a right to we have various rights, and then those rights, we can make demands in terms of those rights, and in terms of emerging needs, we can lobby with the, we have to be able to lobby with the government. Remember that sometimes the government is not empathetic to our concerns. We may have a emerging corporate state which is more concerned about the profits for the majority, and for select, not majority so much as profits for a select few at the cost of the people. So it would need a lot of organizing, but at least we have the framework, and we have to make sure that that framework is not altered. And we have to make sure that where that framework is being altered, or where laws are being enacted in violation of that framework, or where there is a shortfall in terms of the requisite laws for emerging situations. We have to be an active citizenry and use the constitutional framework. So it is in this context that that I am making this presentation. I will share a PPT with you. I'm sharing it on the screen. Yeah. Are you all able to see it?
Yes, ma'am.
Yeah.
Yes, ma'am.
Yeah. So yeah, my session is on operationalizing constitutional framework in public policy enforcement, because basically we are looking for public policies which will embody the constitutional framework, the frameworks of rights, the frameworks of the frameworks of a certain democratic mechanisms. So essentially, operationalizing the constitutional framework in public policy enforcement means defining the constitutional principles that should guide public policy. I mean, people's participation, whatever it is, fundamental rights, etc. And then ensuring their effective implementation across institutions and jurisdiction. So how does one do that? At one level, uh, there are certain obligations cast on the state through their various through their various arms, as well as through their various institutions, to operationalize these constitutional principles in public policy. And at another level, we have a responsibility as a citizenry, as a responsible citizenry, to ensure that the state does what it is obligated to do. So therefore we first look at the defining the constitutional principles that should guide a policy. So here we have so why do we do that? Because we are doing this to ensure that civil liberties and fundamental individual and community rights are protected. Now you do have examples of how public policy has been operationalized, first through sometimes through court judgments, sometimes through legislation. So, for example, we had the Vishaka judgment when it was realized that the rights of a woman to her to work are affected because there is incidence of sexual harassment at the workplace, which deters a woman from going to work, and yet at the same time she requires to work. That is how we have the Vishaka judgment, following a petition that was made in the wake of several cases of sexual harassment at the workplace. A couple of several cases, but some of them had been highlighted by groups across the country. And so those were put together with the experiences of the organizations that had worked on those particular cases. And this petition was made for some kind of directives from the court in the absence of legislation from the state on the issue of sexual harassment at the workplace. And that is how you have the Vishaka judgment. And then subsequently, although there was a judgment, the Vishaka judgment had said that these are going to be directives till the state comes out with a law. However, the state was just not coming out with a law. There were drafts, there were various bodies making drafts, organizations making draft sexual harassment laws, but the state somehow needed another what you call catastrophic event, or something like a mobilization that had to be galvanized over a catastrophic event for them to finally come out with a sexual harassment law. But still it happened, and we do have a sexual harassment of women at the workplace law, sexual harassment of women at the workplace prevention, prohibition, and redressal law. Then you have the disability law that protects the rights of persons with disability. That also, I mean, has been the result of sustained demands from the persons with disability. The law has also evolved over time. There were different legislations, and previous legislations have been repealed, and now you have a new legislation which recognizes, for example, that disability is not just a a biological construct, but it's also a social construct. Then so this is one reason we need to make sure that as the discourse is evolving, as the lived experiences are coming forth, that these have to reflect in the public policy. If they don't reflect, then that does not meet the evolving needs of the populations of various sections of society. So therefore, to ensure that we need to make sure that the constitutional frameworks are operationalized in law. Also, in terms of transparency and accountability. Now, if you can have a lot of wonderful legislation, but maybe it's not in a language of it's not published. Or you may have, for example, there is a Goa I'm just giving you an example of Goa. There is a police service law which details the process of inquiry against police officers once you complain about a police officer violating the civil service rules. But that police law is not accessible to the public. It is not available in the form of a publication in the government printing press, where all these various government, the local government laws as well as national laws are available. It's not available there. It's not available in the public domain as in the form of a printed book or anything. And it's not available on the police department's on the website as well. So now if you do not have that law, if you want to make sure that a departmental inquiry is initiated against a police officer who has transgressed his or his powers, then if you do not have access to that law and know how the process works, you will not be able to hold them accountable. So therefore, there are times when there are various levels at which demands have to be made. So for example, here you would need to go public about and organize a campaign that this law should be made public. So this is just coming to light now in the recent in the face of a series of recent incidents where police gundagiri, dadagiri has been happening. So that one needs to know what their laws are, what their accountability is, how can there be inquiries apart from the general law of the land. Now we know that the general law of the land, like in terms of criminal cases, etc., then you need sanction because they are police, because they are government officers. You need sanction from the state, and then that takes its own time because they say they acted in the course of their duty, etc. So the point is that there are all these issues. So therefore, it may be useful to look at mechanisms of accountability that are doable, that are more accessible and people friendly. And yet the point is that they may be people friendly, but the book is not available, or it's not translated in the language of the people who have to use that book, the publication. So here we need to ensure that this happens, that there is transparency. Otherwise, we may have rights. We may have we may ask for transparency and accountability and equitable service delivery, but there may be there may be no the tools for making it transparent, accountable, and equitable may not be available, and therefore it might mean lobbying with the government, or meaning making representations to the government, lobbying with the legislators. So then the other thing is the rule of law has to be upheld. That is why we need to operationalize the constitutional framework. You cannot have a situation where somebody says that I am above the rule of law, or I am God, or I am whatever. So we have to make sure that nobody can hide behind any such statements and say that I am above the law. So the thing is that for this reason, and therefore we have, like, the mother of all laws, the Constitution. to fall back on in the event this something like this should happen. So, so essentially, what I would say is that these are all the various constitutional. This is part of the constitutional framework. So you have the fundamental rights. I presume you are all versed with this. We have fundamental rights: right to life, especially right to equality, right to life and livelihood, right to freedom of speech and expression. These are very core rights of in the Constitution, and we have to ensure. I mean, basically, these core rights, since they are guaranteed in the Constitution, we have to ensure that anything that is done in the name of public policy does not violate these fundamental rights, and also, in fact, not only does not violate, but proactively the public policies must reflect these fundamental rights. The other thing is the directive principles of state policy. So now India has also ratified certain, international conventions. And one of them is the Convention on Economic, Social and Cultural Rights. So once certain policies have been set in motion to operationalize the directive principles, although we have our constitutional framework says that nobody can insist that like fundamental rights, you can insist, this is my right, I have to get it, and my right cannot be violated. But with what is set out in the directive principles, you cannot say, this is my right. So the point is, but if the government has already enacted legislation in furtherance of the directive principles, then it cannot regress on that. So once it is enacted, because India has ratified the Convention on Economic, Social and Cultural Rights, which are mostly the kind of rights that are embodied in the kind of directives that are embodied in the directive principles. Once they have enacted something, a legislation, they cannot regress. They cannot say, no, now it's part of the directive principles. We're not really obligated to provide all this. This is like ideal, but we're not obligated because they've already enacted legislation. Meaning maybe not that particular government, but an earlier government may have enacted it. Maybe an earlier government that was maybe more responsive. But this government now cannot go back on that. So these are directive principles of state policy. Then you have the basic federal structure. So the federal structure of the Constitution respects not just the central, the supremacy of the center. It recognizes that there are different states that have become part of the Indian Union in different circumstances and are sometimes differently located because of their geography, their history, or various factors. And therefore, this needs to be respected in terms of nuancing the legislation, certain kinds of legislation in each state. Therefore, you have in the Constitution, you have what are called central subjects, you have state subjects. That means central subjects mean if it's in that schedule which deals with central subjects, then it is only the center that can legislate on those subjects. If it says it's a state subject and it's only the state, and then it's important for us to know this, because if we are looking to operationalize the constitutional framework in public policy, we must know who is the competent authority to, for example, come out with legislation on this subject. Who has the kind of monopoly over that area. So you have a federal structure. And there's also a third list. So you have like the central list, the state list, and you have what is called the concurrent list. The concurrent list is the list that where it is open both to the state and the center to legislate on those subjects. But if the center has already legislated on that, then the state would require to take certain permissions to legislate differently. So then that's also part of the That's also part of the basic, the basic constitutional framework. And then, of course, last but not the least, the democratic mechanisms that have been embodied in the constitution. They may be legislative mechanisms, judicial mechanisms, mechanisms for the executive in terms of regulatory systems, or other institutions, which are statutorily legislated as institutions within the framework of the constitution. So now we have to ensure that this entire band of constitutional framework is operationalized in public policy, is not violated through public policies, and is actually proactively operationalized. So therefore, public policies have to be rooted in this constitutional framework. Now, what are the various stages, if one may call them that, in terms of how can we work towards ensuring that it's operationalized? Now, one is, for example, identifying contentious aspects in public policy. Example for restrictive protection, no training for a technologically, so for example, if you have let us say there is a public policy that says that, okay, now you can you can access, you have online access to various certificates, but you have not, the internet network is the digital network is not, it's not working, it's not operational, so there's no connectivity, or the people are not trained to operate that. So then you have having an online access, and there are no, let's say, kiosks at various rural points, there's no connectivity, widespread connectivity, then this is online access might seem a good thing, but if there are no kiosks or something where people can access these online and get certificates, let's say if they want a certificate for residence certificate, they should not have to come all the way to some place, given our given technological advancements. These advancements have to be for people. But if they don't have all this, then they will not be it will not be operational. People will not be able to access their rights. So this is about, so when we work with a section of people, if we find that these are the, let's say, if we are working with hawkers, and if we are working with hawkers and it's about marketing. Now, some states had evolved some methods for marketing online, for, but then there was not the capacity that was built in some of those states for people to enable these persons who wanted to access this to be actually able to access this online systems. So then if you're working with hawkers and not only hawkers, but people who have to market their wares, like farmers or people, then there should be you could identify that, you might identify that these are the problems. So you have to identify what are the problems, because let's say they are not able to sell their produce. So then you identify, then they say, the government says, okay, we are now going to, if you have excess produce, we are now going to do it online. So then they say they're doing it online, still they're not able to sell. So then, because the government has projected that as a solution, and maybe you also think it's a solution, but there are barriers. So those barriers have to be addressed. So they have to be identified in order to be addressed. We should also be aware of some pivotal moments in governance. For example, we have the 73rd and 74th amendments, which are, for example, the 73rd amendment is about Panchayati Raj, and the 74th amendment is about Municipality Raj. That means that local self-governments are significantly empowered. Now, if these local self-governments are significantly empowered, we might consider you instrumentalizing, or rather, so for example, the 73rd Amendment, through the 73rd Amendment, panchayats have had to, meaning states have had to enact Panchayat Raj Acts, and then those Panchayat Raj Acts have various provisions that they're required to have as per the 73rd Amendment, which includes reservations for women, which includes power to the Gram Sabha to take a call on the development of the village. So now, if we know that there is power to the Gram Sabha, we might want to, for example, take the issue of the vendors or the farmers. We could bring this issue up in the Gram Sabha. So here you're operationalizing a constitutional framework to access the rights to access rights to life and livelihood. Because if you cannot market your produce, if you're putting in so much investment in farming and you cannot market your produce, then you're not going to be able to your life and livelihood may be at stake. So then one can try to raise this issue concertedly in an organized way in the Gram Sabha. And of course, we know that at a smaller level, it might be easier. At a bigger level, there are other dynamics that play at the level of member of parliament, etc. Because it's about a vast, area that is covered, a vast number of people that are covered. But at the local self-government level, the panchayat wards are relatively small, and people can exercise their power to ensure that once they raise this in the Gram Sabha, if that issue is neglected, one is the law itself gives them a certain power. And the second is that if the panchayat is not responsive, they can ensure that they are defeated at the hustings. So these issues can be raised as a charter of as part of a charter of demands of the constituency that you work with, or as part of a larger civil rights movement or whatever that we work with, or if we are in governance, we can try to see how those concerns get operationalized. So it depends on where you are located in terms of how you can attempt to operationalize. What I'm trying to focus on is that the constitution is a wonderful framework, and if we want to, we can kind of hold it by its hold that constitution and use that constitution to ensure that to try to ensure democratic governance that where people's rights to equality, life and livelihood, speech and expression are protected. So then it's also about, so now if we do realize that for example, with a consistent demand of people, of the women's movements and women's organizations, women's and various concerned citizens, we have like the law on protection of women from domestic violence act, on protection of women from domestic violence. Now it was enacted in 2005. Now that law has got provisions. It provides for certain mechanisms for redressal of domestic violence. It provides for certain functionaries to operate under that. For example, there is somebody like a protection officer to whom woman can report about domestic violence. Now, if that protection officer fails to discharge his duties under the Domestic Violence Act, he can be held accountable. There are very specific provisions. So one is we have to embrace such provisions. Now, if we find that that provision is not adequately worded, that a protection officer can be held accountable, we have to find ways to fine tune that provision and make demands for fine tuning those provisions for kind of reinforcing the existence of those provisions, drawing attention to the existence of those provisions, and validating them through making demands to ensure that those provisions are enforced. Okay. This of course involves looking at the texts of the laws that at least we are immediately, besides being aware, having some basic knowledge about the constitution, about text of the laws on the areas that we are working on at least, and some general laws like right to information is a very would come into play for everyone. So and then laws like as I said, there are accountability provisions. There are accountability provisions in the Domestic Violence Act. There are accountability provisions in the Sexual Harassment Law, Environment Protection Act. There are some kind of accountability provisions. So we should be cognizant of those, so that when we make demands, if our demands are not met, we must or when we make demands, as in when we make representations, rather I wouldn't say demands, when we make representations that okay, there is this thing in the law but this is not being happening. For example, in the Environment Protection Act, there is a need for an a public hearing, let's say, for a certain kind of industry, and the public hearing is not happening. They may quietly try to shelter and say that they were not having the hearing because it doesn't come within the scope of those industries that require a public hearing. Then we can show that we are aware now that that industry does come. So we can point out, but for that we need to be aware. So at least we should familiarize ourselves with the existing legislation. And let's say there was the public hearing is held and then there's no pata, there's no news only about it. So then we can ask for information under the Right to Information Act, so that we make sure that these provisions in the law are not just on the book. Very often what happens is there are demands from society for the laws, but once a law is enacted, we are very happy that we managed to get this law enacted, and then we forget to make sure that it's operational. Sometimes there are setbacks in terms of operationalizing it. There is some judgment that doesn't come in our favor, and then we get put off, and then you don't want to go further. But that's not the way, because if in the end we feel that some law that we asked for is not serving the purposes for which it was enacted, and it cannot serve because there are certain limitations in how the law is worded, or in the operation of the mechanisms that are worded, that are provided for in that law, then we have to make sure that we ask for changes. So that's very critical if we want to operationalize. So now the thing is that we would want to make public policies work for people through various systems. One is through the judiciary. Now the judiciary would mean, like, for example, if legislation were to be enacted, that is let's say we can ask for judicial. Now, for example, there was this recent judgment which I shared with you as a reading on climate change. Now, basically, it was a judgment. It was a case where the petitioner made a case for the preservation of this thing called Indian bustard. The bird called Indian bustard. But in that, because the preserving, the conservation of that was by saying that you shouldn't have renewable energy thing, because those wires, they kind of create a situation which is endangering the Indian bustard. So the judiciary therefore looked at the competing rights, meaning competing interests, because at another level, renewable energy is required to prevent climate, meaning to prevent further exacerbation of climate change. So how do you balance that with the preservation of the Indian? But the Indian bustard also plays a role in protecting from climate change through some of its practices. So how does would both the interests be taken care of? So the court did a review, therefore, in the light of these competing interests, looking at what would be the responsibilities of the state in these circumstances, and it came out with a landmark judgment in that case, which I would urge you to read, because I do not have the scope and time maybe to look at that now. So now this judicial review can happen because you made a public interest, filed a public interest litigation, or It may also be that at a very, very localized level, at a very primary level, not necessarily a writ petition, because sometimes people go in for public interest litigations because they are more high, they have high decibel value. But sometimes we must know that we have to be strategic. If we haven't built the grounds well, if we haven't built the material that we need to kind of impress the court about the need for those demands that we are making, prayers that we are seeking, to the reliefs that we are seeking through the public interest litigation, the whole thing can fail. So it might mean making, they may say, for example, that you could go to this court for this relief. Why have you come here? There is already a law. So you have to show that you went under that. If there was something like that, if there was a law, you have to know that there was a law, and that you went and it's not catering to that particular concern. And therefore, you might file strategic litigation. I mean, as in you might make strategic demands at the various levels of administration, or in terms of operationalizing certain rules that are there. You may go to the collector, let's say, or some administrative officer who is empowered to say, okay, this is provided in the rules, but you're not providing it. Let the person say, I cannot do it within the framework of these rules. Then you can go to the judiciary and say this is not taken care of because these rules are inhibiting. So it's also important to document landmark judgments in the area that we work in, whichever be the area, and some central judgments, core judgments, which are not necessarily only about the area we work in, but which are very basic and core. Like, there are judgments that say that judicial review is possible, but judicial review is possible. And that judicial review itself has held that the basic structure of the constitution cannot be changed. So we should know these things so that there's certain basic knowledge that we have. Then there is the whole question of the government departments, Niti Aayog. There are regulatory commissions. There is, like, for example, now the Inland Waterways Authority of India. Now, on various subjects. Now, the point is that some of these laws itself are problematic. There has been a lot of resentment about the Niti Aayog because of the way it has been operationalized. So you have sometimes problematic setups, but now when those setups are there and there are no other setups, you don't have the planning commission. So now you have a Niti Aayog, right? So if you have a Niti Aayog, you have to tap that Niti Aayog. You have to tap whatever is there. You can also challenge any of these bodies that are set up which are not fitting within the constitution. But, or for example, you can try to raise the issues. Now, for example, Goa raised the issue that certain waterways were declared as these inland waterways. Now, when these waterways are declared as inland waterways, ostensibly in the name of protecting those waterways, what actually it means is that people have no rights to making any decisions regarding the planning in the areas around the inland waterways, or in the planning of the shores of the waterways, etc. The local people have no right. It takes away the 73rd Amendment, 74th Amendment. And besides that, it's a state subject. So what we had done is to expose the government. We did not succeed in removing those waterways from the ambit of the Inland Waterways Authority, but we exposed the government that the state government put a noting saying not objecting to these waterways being notified as national waterways. So in that sense, it plays a part, because when you do these exposés also, what happens is that the people in those areas who are suffering the consequences, for example, fisher people cannot access their fishing areas because of the kind of legislation that has come. When you expose that, then the fishing community will rise and make sure that at the ballot box they can reflect their resentment. So there are various ways in which we can ensure that people's rights to life and livelihood, the constitutional frameworks, are operationalized in public policy. And if they're not operationalized, or they're operationalized contrary to constitutional principles, then we challenge them. Then, of course, as I said, public hearings, consultative processes. And then there are also human rights institutions which can monitor. And there are various human rights institutions. There are the General National Human Rights Commission. Then there's National Commission for Women, Children's, the Disabilities Commission, state. Then there are at state level also, state human rights commissions, state commissions for women, state commissions for OBC, state commission, etc., which can monitor the constitutionality of the laws being enacted. If the laws that are being enacted are violating the basic rights of the particular constituency that they're supposed to they're supposed to address. Of course, as I said, there is the thing for judicial review. I'll not go into that now in more detail. Yes. I think I will end here and let us have maybe a discussion now on this, because it's a question of time. Yes.
Thank you, ma'am, for providing such a comprehensive and enlightening session. Now, we invite Professor Vibhuti Patel ji for her remarks.
For a very, very useful, insightful listening for all citizens and also the participants here. I wanted to, can you just inform us about the roles and powers of various commissions such as Child Rights Commission, Child Protection Commission, Women's Commission, Scheduled Caste and Scheduled Tribe Commission, and also how are landmark judgments different from core judgments?
Okay. So the thing is that first is you were asking about the human rights commissions. Now the human rights commissions basically have powers to address any grievances or violations of human rights, and it's a very it's not an elaborate court procedure like policy system. You don't need to you don't need a lawyer really if you are familiar with what you're working on, and you might just need a lawyer when the opposite party, who's like a maybe not an opposite party really, it's the state, but the state is backed by corporates and they seek to intervene sometimes, because the challenges are sometimes where the state has the pollution control board has given a powers and has given a license to operate when they're already known to have a record of pollution beyond permissible limits, for example. So now, so you have these corporates working in as interveners, saying that if if the Goa State Commission Pollution Control Board is what do you call it? There is pulled up by the Human Rights Commission, then they will cancel their license, and then that will their rights will be affected. So they come in. So then when they come in with their lawyers. So then that is quite a thing for intimidating environment. And then they start pointing out to some technical points in the human rights law as to and then the person is not able to they're not looking at these minute words in the law, right? So then it might need assistance of a lawyer at that point. But yes, so basically the human rights commissions can address grievances and make recommendations. Now many people say the human rights commissions, they make recommendations, so what's the use? But we must know that the law is drafted in a way that the recommendations of the Human Rights Commission are binding on the government. And if they do not want to follow those recommendations, if they feel that those recommendations cannot be followed, or there is a reason not to follow them, they're bound to give reasons as to why they're not following them. Which is why that is constantly being challenged, because that's not happening. And the human rights commissions itself are failing in the sense of not seeking accountability from the state for for when the state is not following their recommendations, or and not even giving any reasons for not following them. And that is why there have been movements, civil society movements, which have said that our human rights commissions should not get that accreditation, that they are desperately seeking to be in the committee of, to project themselves, the state to project itself and cover up its violations. So the thing is that, I'm just giving you one example. But basically, the Human Rights Commission also has at its beck and call an investigative body that can do some inquiry, because a lay person may not be able to say, for example, in the same example that I gave, a lay person may not be able to walk into the factory and see what is happening. They will not allow. So therefore, the investigative body that they have at their disposal can go in and do an inspection. We can ask for that, and a surprise inspection. Of course, with everything, there are ways that people circumvent. They alert the other side, for example, or whatever. But we have to be also innovative and creative in what happens. Or when they come, they may not make a proper report. So we have to videograph them with videographing, so that you show that they have not put all the records, all the videos that they took on record, for example. So we have to be like 10 steps ahead. So that's National Human Rights Commission. Now, the other human rights commissions do not have that level of powers to the extent that their recommendations are binding. But like the provisions in the National Human Rights in the Human Rights Commission law, but in the Protection of Human Rights law, but the thing is that they are still those reports, for example, the report of the State Commission for Women. I'm giving you an example. The Goa State Commission for Women Act requires that the reports of the State Commission for Women be tabled in the assembly. So then when they're tabled in the assembly, we have to be able to utilize the assembly legislators utilize, as in what I mean is to lobby with them to raise questions in the legislative assembly. So it's about tying up in terms of how we use this. But as I said, these various commissions are expected to look at the particular constituency. That it's a commission for women and women, child, whatever. So
SC, ST, the person with disability. There are so many commissions we have, no?
Yes. And they also have a responsibility, besides the specific grievances that people address, they have a responsibility to review the laws relating to women, for example. So that is irrespective of a grievance being made. So they can review national, even state commissions can review national laws. And also review state laws, of course.
Yeah.
If they find that they may not be able to review a lot of the laws, because that's a lot of work, but they can at least review the laws that are seen as not addressing significantly the subject that the law is based on, or in fact being counterproductive. Sometimes you have laws against trafficking or something which are counterproductive in how they how they have the definitions, etc.
Yeah, correct. Because they penalize the sex workers rather than the procurers and pimps and those who control them. So
yes.
That is it. Another thing
the other question was the core judgments and the landmark judgments. So the core judgments are judgments. For example, you have the Kesavananda Bharti case. That is a core judgment which says that you cannot, by a law, change the basic structure of the constitution. So, for example, if the basic structure is about ensuring fundamental rights, secularism, socialist, socialist state, sovereign, democratic, socialist, secular republic. So now you cannot change that. Now, if you change that, then if there is a law, or let's say tomorrow they even try to amend the constitution to say you should have a state which is a theocratic state, then that would be changing the basic structure of the constitution, and that can be challenged in the Supreme Court. I mean, I'm saying at the level, even at the level of constitutional amendments. Also at the level of, and that Kesavananda Bharati case was in the context of certain changes that were proposed to be done in, I think it was in 1975 or 76. Now,
emergency
yes,
with
yes.
regards to emergency.
Yes. So that's the thing about the basic structure of the constitution. So therefore, if you come across any legislation in the area that you work on, where in the process, let's say you work with on communal harmony, then if there is this kind of a change, you know that this law is what you can hold on to. Although it is not only dealing with that subject, it's a core judgment. Now, the other thing is these landmark judgments are like, say, for example, there was a landmark judgment on disability in, I think it was in 2021 or
2004.
no, there was one about workers at the employees at the workplace. The specific provisions on disability for employees at the workplace, which is the one that also not only looked at that specific issue, but looked at disability as a social construct. So you know, to kind of absorb these concepts and link those concepts to what is happening, how the people will raise it. So we have to ensure given our location, we have to ensure that there are synergies between these evolving concepts, at least the progressive evolving concepts from the progressive ones I'm talking about, and the demands as they are vocalized, you know, so that we can take it further.
Understood.
Questions?
Fellows can now ask their questions. They can either raise their hand or type their questions in the Q&A box.
Directly ask this.
Is someone asking a question?
Anyone who would like to ask some questions?
Or even share.
Okay. So we should move forward. Thank you, ma'am. We at IMPRI hope you continue to collaborate with us in the future as well. Moving on to our next session, I'm honored to invite Advocate Dr. Shalu Nigamji for a legal hands-on session. The floor is all yours, ma'am.
Thank you so much. And Shalu, I would just like to share my slide. Sorry. Yeah, so we have just spoken about, you know, how the judiciary can play a significant role in, you know, policy making and, you know, enforcement of various laws and policies. So today I'll just talk about judicial activism and backsliding, which is, you know, happening in India. So we know that public interest litigation, we have just heard about it. It is also called social action litigation. And if you talk about, you know, it's in simple word, it means litigation which is filed in the court of law for the protection of public interest. Now, what is the public interest? It could include pollution, road safety, construction hazard, anything. Which is not definitely, which may not be defined under the law, but it could involve, you know, violation of basic human rights. It could involve a basic government policy which is not working. It could compel municipal authorities to perform a public duty. So, you know, these kind of things can come under, you know, public interest, the definition of public interest. So it is also known as the power of courts. You know, through judicial activism, judiciary can actively, you know, play a role in, you know, handling the basic issues. So, and it can handle interest, any area which is of public importance, it could be of community interest. So basically, any citizen can go to the court and can say that, okay, this policy is not working, this law is not working, my rights are being denied. So that kind of cases can come to the courts under public interest litigation. Justice P.N. Bhagwati, he has said in 1981 in one of the judgment, the court has to innovate new methods and strategies to provide access to justice to large masses of people who are denied human rights or freedom and liberty. So if we look at the history of public interest litigations, basically it started in USA. In US, this term is known as public interest law, and this name is given, so as to provide legally representing people who are underrepresented. That kind of, you can also see a pro bono kind of lawyering. So basically, it involved, because in the marketplace, in the legal service marketplace, some people cannot afford the law. So they cannot afford to pay the fees or the lawyer fees or the court fees. So, and there are basically issues such as environmental, consumer, racial and ethnic minorities. So basically they have that kind of provision. In India, what has happened is that during the emergency, when there was state repression and there was lawlessness, so thousands of people were sent to jail, and post emergency, when this emergency ended, the judges they have openly said that the justice must be provided to the poor. So Justice P.N. Bhagwati and Justice Krishna Iyer, they have played an important role just during 80s, during late 70s, 80s, and early 90s. So they have provided, access to justice to poor and exploited people. And also at that point of time, the journalism was very investigative, and they exposed, a lot of lawlessness, repression, the cases of custodial violence, and they draw attention of lawyers, judges, and social activists. So PIL emerged as a form of collaboration of proactive judges, media, people, and social activists who come together and created that kind of environment. And this was in stark contrast with the traditional justice system, where judiciary is performing more of the role of an activist. In other kind of legal cases, we have this issue of that only if I am aggrieved, then only I can go to the court and file a case. But in this public interest litigation cases, the court has expanded this notion of who can file the case. So a writ petition can be filed by any person who has suffered the injury, and also by any people who say that we are working for social cause. So that right has been elaborated. And why this right is elaborated? If you see Article 39 of the Constitution, we have discussed this earlier when we talk about Lok Adalats and other things. So basically, under Article 39, it says that people should have access to justice, and they should be provided legal aid. So basically, what has happened during the 70s and 80s was that even your letters and telegrams were treated as public interest litigation. I remember reading some of the cases where people from the jails, they have written the letters to the court, and the court treated it as public interest litigation, and they have proceeded with the case and provided relief. So these kind of things, social transformation was made possible, because of this concept. Otherwise, any person can file a writ petition under Article 32 of the Constitution or 226. Under Article 32, you can go to the Supreme Court and you can say that my fundamental rights, given in the Constitution, they are being violated. We have just discussed about Article 21 and other rights. So if those rights are violated, I can go to the High Court under Article 226 and can say that the court should provide me protection. So basically, it was seen as a boon for citizens of the country, and so many of the people, individuals who have filed litigation and social action groups, many social movements, they have filed various kinds of litigation before the court to eliminate poverty, to take up the cause of environment, to take up the cause of differently able people. So many petitions have been filed, and Justice Bhagwati has elaborated on, what are the essentials for the PIL. So he says that the aggrieved party must be the victim of legal wrongdoing, and that which is punishable as a violation of his or her constitutional rights. The victim must be in position where she is unable to contact the court for various reasons. It could be poverty, it could be various other factors. The person could be in jail, or there are various other factors. And if all these conditions are met, any public representative or the member of his family, they may file complaint on the behalf of the victim, and the court must ensure that PIL serves the public interest and they are for greater good, and it's not for the victim's personal benefit. So how can you file PIL? The procedures are that you have to make an informed decision. You have to consult all the affected interest groups. You have to be very careful in filing a case because litigation can be expensive and time consuming, and any adverse decision can affect the strength of the movement. So you have to, before filing a PIL, you have to collect all the relevant information. You have to gather the details of the case, if there are any photographs, if there are any other kind of evidence. So you just you have to go through that to maintain records in organized fashion. And PIL can be filed by any registered organization. It could be filed by a person in his or her individual capacity. So you can file a public interest litigation against the state. Basically, under Article 12 of the Constitution, the state includes the government of India, the parliament, the state legislatures, so all local authorities, and a private person can also be included as a respondent. For example, in Mumbai, there was a case which was filed regarding pollution, and it says that it made the parties to the state pollution control board, and also a private factory in Mumbai which was causing pollution. So the impact was that PIL has successfully asked the official authorities. They have hold them accountable. They have ensured transparency in some of the cases. In cases of environmental grievances, the socioeconomic rights, the right to food, we have we have discussed that earlier, and also the Vishakha judgment, which we have just now discussed. So this is how PIL has played an effective role. And the courts have said that it has interpreted the provisions of the Constitution and the laws in a much broader way to protect the rights of citizens. And in some cases, the courts have taken suo motu action, that means on their own, based on the newspaper reports. For example, recently there was this public interest litigation which was filed in Odisha High Court, where 11 children were suffering from severe malnutrition, and the court asked the state to respond, and the government says that it has taken some some measures, that there are some government schemes, but the organization which has filed this case, they say that the people are not given food because they do not possess the Aadhaar card or a mobile phone, or they don't have proper papers of identity, and therefore they are being denied food, and people are still suffering from malnutrition. So the court has given various orders and said that the government should provide food, even if the people don't have their identity cards. If you talk about environmental, MC Mehta versus Union of India, if you just do the Google search, there will be a lot of cases which will appear, and because he has filed number of cases, say, against the Taj Mahal, against Mathura refineries, to control the pollution in Ganga Basin. And there's so many cases, and 70s, 80s, and 90s, you will see the orders, the vehicle, pollution which is caused by vehicles. So many orders have been, given by the courts in such kind of cases. In one of the case in 1981, the brutalities of police were, taken up by the courts based on the newspaper report, which says that 33 criminals were blinded by the police in Bihar by putting acid into their eyes. So the court immediately said that the government should, state government should bring the blinded men to Delhi for medical treatment, and it also ordered speedy prosecution of the guilty policemen. In another case, this was about the handcuffs, and the court says that it should not be forced upon a prisoner. And in various other cases, the court has said that prisoners, should not be forced for, handcuffs should not be forced on them. But right now, what is happening under the BNS, the new law which is coming up, Bharti Nyaya Sanhita, the handcuff is being, provided in some of the cases. So apart from that, so in Sheila Barse versus State of Maharashtra, this is very famous case where a journalist complained of custodial violence against women prisoners in Mumbai, and her letter was treated as a writ petition, and the directions were given by the court to improve the situation of women in jail. So there are cases after cases where, I can go on and on about these cases, that how the situations of people in custody have been improved in Agra protective homes for women, in terms of custodial deaths cases in various places. Also, the right to health was elaborated in Permanent Kataria versus Union of India, where court says that without the legal formalities, in cases of emergency, immediately the treatment should be provided to the victims. The doctor cannot say that first you complete the medical formality and then we will provide you treatment. There are also cases where tribal rights are being protected. The Supreme Court has said that industrialist private companies and non-tribal people cannot access the land owned by tribal people for mining or leasing purpose. The courts have also gone to the extent of protecting child rights to the education, to health and development. In Bandhu Amukti Morcha, the courts have given order that the Child Labor Prohibition and Regulation Act 1986 should be enforced to eradicate child labor and bonded labor. On manual scavenging, now recently, this is again a recent judgment by the Delhi High Court, where some of the workers who have died while doing this scavenging work, and Delhi Jal Board, the High Court says that state should pay compensation, and Delhi Jal Board came before the Supreme Court, and it says that we can't provide any compensation to these people, but the court says that it is the duty of the state to protect the workers, even if they hired on contract or whatever ways. So the state should provide them safety, and it says that human beings are doing work, who are doing work in seaward, they cannot be treated as robots, because basically they were going inside the drains without any protective gears or safety gears. So High Court has awarded them compensation of ₹5 lakhs per family. But the problem is that one cannot file frivolous PIL, and this trend of filing frivolous or false cases, it has come in recently, and the courts have started imposing fine on litigants for filing false cases. In several cases, the courts have gone up to the fine from rupees lakhs, 10 lakhs also. So basically, you cannot file false cases. So these are the various examples of cases where the court says that nobody can misuse PILs. Again, these are again various cases. This is the list somebody has prepared for, of cases which have been, dismissed, and the court has imposed fine on such petitions. For example, someone has filed petition that center should construct a great wall of, throughout the entire border of the country, and this petition was dismissed. Somebody said that lower the marriageable age for men from 21 years to 18 years. Again, this petition was dismissed. Somebody filed a petition saying that rename India as Bharat, and this petition was again dismissed. So these are the kind of cases which have come up and petitions were dismissed. You can see that this article appeared in Outlook in 2019. There's a study which has been conducted by the World Bank in 2009, which says that PILs constitute less than 1% of overall caseload. So if the courts are saying that because we are burdened and if you're filing false PILs, so our burden is increasing, but this study says that only less than 1% of PILs, if you see the loads of cases and PILs, it's just 1%. And out of this 1%, a very low share of cases have been brought by NGOs or cooperative entities, or talking about fundamental rights, because many of the cases have been filed by one corporate against another corporate, or by the state against one body against another body, or sometimes even the state employees, they file PIL because to stop the promotion, to stop the transfers, and these kind of cases are also coming to the court. So coming to the judicial backslide, now recently many of the NGOs and the lawyers are saying that there is a kind of judicial backslide. We have seen the phase of judicial activism during 80s and 90s, but now the things are going the other way around. It may be because of increasing workload on the courts, and some judges, they have made remarks that it's a sorry state of affairs because sometimes the laws are not made correctly. Some of the judges have said that the laws are badly conceived, or they are passed without discussions, or there are ambiguities in the law, and all this indicate that the standard of lawmaking is being falling over the years. So these trigger unnecessary litigation, and which is causing inconvenience to the courts. The state has, the courts have been saying that the state has remained the biggest litigator, and it is piling an burden on judiciary by filing interdepartmental disputes, police making illegal arrest, cases of custodial torture, contempt petitions, government employees, they're filing cases relating to promotion transfer, which could be avoided by following the due process. There is a report which came in recently, by the civil society campaign, and it is called by Vada Na Todo Abhiyan. Now, this is a kind of organization which has compiled the report of 4 years of NDA to government, and the report is titled as Promises and Realities, within past few years, and it raises various concerns about bulldozer justice, judicial backlog, hurriedly passed laws, and also the appointment of judges. Several senior lawyers have also said that judiciary is not, taking action in many of the cases, and basically, if they say the trend is going the other way around. Earlier, we have cases like Olga Teller's case, where the cases where the court has said that from the pavements, citizens cannot be removed, and they shouldn't be shifted. If you read this Olga Teller's judgment, and now there are judgments where bulldozers are being run on people's houses. We are seeing every day. So these kind of transgression of laws, and judiciary is not taking action on that. So even the state is doing that, and judiciary is not taking action. So that's why that is the reason that people are saying that there's several human rights activists, journalists, students, people who are behind the bar, and these cases have been pending for so many months. And generally the rule is that bail should be provided, there should be no jail. But in this case, it's the other way around, which is happening. So these are the several of the readings which you can take up. So I'll just stop here, and maybe we can take up more questions. And
Thank you, ma'am. Fellows can now ask their questions. Anyone who would like to ask some questions? So we should move forward. We are now moving on to participants' creative project presentation. Participants who are ready to present today, kindly raise your hand so we can move in an orderly manner.
Shalvi Shahji, would you like to go first?
Yes, so I'll just give a brief of what am I going to present. My research is on the topic, which is titled as Bridging the Gap Through Project MAS, which stands for Menstrual Awareness, Hygiene and Sanitation, and how role of public policy in reducing menstrual health disparities among low-income women in India can help. So I'll be sharing a visual, which I have made, which is somewhere around 3 to 4 minutes. Can I get the sharing rights?
Yes, sure. Yeah, Shalvi ji, just join as the panelist. Yeah.
You can also put your video on. Camera.
Can you just give me a minute? I will start sharing my screen.
Meanwhile, other participants who are ready to present, you can put your names in the chat box. We had 3 requests from Divakar ji, Gyaneshwari ji, and Khushbu ji that they'll be presenting on the 16th. So that we have agreed upon. Other participants, if you're ready, please put your names.
Can you see my screen?
Yes.
The voice audible to everyone?
Yeah.
Yes, you are audible.
Shall we not like this?
Sorry.
Yeah. एक बार stop share. Stop share. Screen share stop once. Yeah. Now share again. A window will pop up. Then see where the video file is. Click on that.
Yeah, I can see it now. Is this better?
Yes. Before that, Shalvi, you can also introduce yourself.
Sure. Hello, my fellow mates. I'm Shalvi. I'm from Gujarat. I have recently graduated from Bachelor's in Business Administration from Ahmedabad University, and I am the gold medalist for my batch with my majors in Finance and Economics. I have also been a student exchange alumni of the United States, where I participated in Young Women Leaders in Public Policy Making. And in this year, I'll be pursuing my postgraduate diploma program in public policy at Indian School of Public Policy in Delhi. I will share my screen. I'll play the video now.
Every woman has a story that makes her feel anxious, scared, and vulnerable. It is a story of a woman's very first period.
Hi, I'm Shalvi Shah, and I'm here to share my first period story through Project Mars.
I remember feeling scared and confused when it happened for the first time. But I was lucky to have the support of my loved ones and help me go through my very first period.
Experiencing menstruation for the first time is a mixture of emotions. It's about nervousness, it's about excitement, and also uncertainty. For some, menstruation or getting the first periods is all about a milestone, but for me, it was a journey towards womanhood. When I got my first periods, I was caught a bit off guard. I was not able to understand what is going to happen with me. But navigating through the menstrual hygiene and menstrual products, I was able to understand my body's natural cycles. Experiencing menstruation for some is a taboo, and for some it's a means of empowerment. I've always considered menstruation to be a source of empowering oneself and empowering women so that they could understand their bodies in a better way. It is something which is pure and not considered to be impure. And with this, I understood that experiencing the first menstruation and the first period is the utmost importance, and it also taught me the cruciality of menstrual awareness, hygiene, and sanitation. Through Mars, menstrual awareness, hygiene, and sanitation, we empower women with knowledge and resources to manage their periods with confidence and dignity. Together, let's break the stigma around menstruation and ensure that every woman gets the access to the support that she needs. Join us in this mission with Project Mars as we create a world for every young girl to provide the information and the support that she needs and create a healthy and a very bright future.
This is the visual that we created for the research that I'm working on. Professor Patel, you are on mute.
Yeah, I think you have covered the issue well, but I think you should also have shown the work that you are doing, no? So,
Yes.
that would have increased the authenticity of what you are saying. Because
Can I
individual
show-
experience, yeah.
Sure. Can I show that since we had the work that we have done, I mean, at some places, it was not allowed to capture it because of the confidentiality of the students who are already there. But we have certain pictures. I can show it if you allow it.
You can blur the faces, no? That is possible.
No,
if
so
they were
I have
question of confidence.
I have a
Yeah.
template, and I have certain pictures which we have made. If you can give me a minute, I can just share my screen.
So I think that that should be embedded in your main this thing.
Sure
Because
thing.
that will
Note.
increase the authenticity.
So if you see that these are the drives, and we have conducted in the first row, if you can see, it is a visual from Anganwadi, which is in Ahmedabad, and we conducted not only just by educating them in a conventional way about menstrual awareness and hygiene, but we started off with the icebreaker to understand that what are the challenges do they face and what do these girls know about menstruation, because the age group that they belong to is somewhere around 13 to 19 or 20 at max. And doing the field work, which I've also inculcated in my research paper, that most of these girls do know about what menstruation is, but from the fieldwork and the surveys that we have done, we understand that they don't know that how correctly you can use a sustainable menstrual product. And some of these girls also used to use cow dung or dry grass or ashes per se when when a menstruation, I mean when they get periods every month. So these are certain visuals that we were able to capture.
Rajasthan, they are also using sand, no?
Yes.
Sand is practical.
Yeah.
So I think if you embed all these pictures with
Sure.
intermittently when you are speaking, that will increase the authenticity, that it is not one individual experience, but even the whole community, how you are reaching out. Your
Sure.
starting point is your awareness, and then reaching out to the people who are not given this kind of supportive, this thing, supported
Noted.
background or supportive.
Yeah. Got it. Thank you so much.
Thank you.
So, anyone else who would like to present?
Who is ready now? Even your work in progress can be shared.
Yeah. I think we should move forward.
Okay.
So now I would like to invite Professor Vibhuti Patel ji for her remarks on this session.
Yeah. I think today we had a very good session. Both of them, the touchstone of constitutional framework for policy formulation. It both the practicing lawyers, they shared grounded experiences, and I think some of the roles of like some of the very proactive judges, they also played a very important role in shaping the whole movement for people's public interest litigation. And as per the Constitution of India, like union is described as India is described as a union of states, and it is organized on a federal lines with jurisdiction of powers between center and states, and independent judiciary to determine constitutionality of actions of legislature and executive. Both Advocate Albertina and Advocate Shalu Nigam, they also very beautifully and very convincingly, they showed the interface between community and the laws and the judiciary, the responses of that, and how the whole series of legal reforms and we got. And during the 80s, we also, the father of PIL, Justice Bhagwati, also gave a very gave a momentum and impetus to the people's participation in the access to justice. Dr. Shalu Nigam spoke a lot about contribution of Justice Bhagwati, but I think we should also get an opportunity to know what was the contribution of Justice Krishna Iyer right from the time of emergency, because he was there in a two-bench, Justice Khanna and Justice Bhagwati. Justice Krishna Iyer, they were also there in the bench when the hearing on emergency rule took place. So I think now Dr. Shalu Nigam can enlighten us about it.
Yeah, that judgment was, very it has been discussed widely, where Justice Khanna, he was the only judge who gave his dissenting judgment, and that really created fear, because generally when you're sitting on a seat, you are there are a lot of pressure from the government, from various other sides, but yeah, he had that kind of courage to give a very dissenting judgment. And there is another side of the story, which is not very well known, is that after giving this judgment, he was not being promoted, and those kind of things are there. But yeah, but at least some of the judges, they do have courage to really come out and give the judgments against the state. And at that point of time, when there was a lot of fear and a lot of things were going on, so I think that really played a very significant role. And even after today, like Justice Khanna, that role, what he played is most of the lawyers, they talk about it, in a very good way, that okay, at least someone who has shown courage during that point of time. So I think everyone should read that kind of that judgment.
Candle in the wind, no?
Yeah.
Yes, yeah. Because even among the academicians, I don't think, except for Professor Rajni Kothari, none of them stuck out the neck against emergency that we saw. The most stalwarts whose books we used to read and quote and all, they all considered emergency to be very progressive. It was mainly to curtail the sectarian and right-wing forces. And same with the judiciary. I think except for Justice Khanna, I think one doesn't know any other. I think Soli Sorabji also opposed, no?
Yeah, and no, basically, I just like to talk to you about the role of Jayaprakash Narayan. I think he played a very important role, because when I go to the PUC meetings, and I heard about his role and the way he organized students at that moment. I think Bihar and Gujarat, they have a lot of student unions, which were very.
We are the product of that, the
Yeah.
Navnirman movement. While Mr. Lalu Prasad and all, they were the product of Sampurna Kranti movement under leadership of Jayaprakash. They were students in Bihar. We were students.
Yeah. So even the philosophy, they come out with like total revolution support, Sampurna Kranti, and those kind of ideology and that kind of thing, that people should have more power rather than the government. So representative democracy, I think many of the leaders were against that. So even Gandhi talked about Gram Swaraj and strengthening the villages rather than giving power, say like centralization of power at
Also, the term grassroots democracy, for the first time we heard of the grassroots democracy, even discovering Gramsci and the role of civil society in shaping the.
So you may be knowing a lot of things about it. I think we should share some these kind of experiences.
No, that's right. No, I said that otherwise it would be incomplete if we don't bring Justice Khanna. That's right. Yeah. Thank you. We had a really lively session. Albertina and Dr. Shalu, both of you made it so lively and very, very, so many thoughts we got. Food for thoughts. Yeah. So
Thank you, ma'am. It's always a pleasure to be learning from you. As we come to the end of day 5 of LPPYF Law and Public Policy Youth Fellowship Cohort 3.0 Summer 2024, Advancing Justice, Bridging Gaps in Public Policy Enforcement, an online national summer school program, a 1-month immersive online law and public policy awareness certificate training course and internship program, I, Ritika Pandey, researcher at IMPRI, Impact and Policy Research Institute, would like to propose a formal vote of thanks on behalf of IMPRI, New Delhi. We are grateful to our experts for the day 5 session, Advocate Dr. Albertina Almeida ji and Advocate Dr. Shalu Nigam ji, for taking out their valuable time, allowing us to learn from this online certificate program. We thank our chair, Professor Vibhuti Patel ji, for convening all the sessions. We thank all of our participants who have raised pertinent questions and actively participated in today's deliberation. We look forward to welcoming you next Tuesday, that is on July 16th, for our day 6 of this certification course. We are grateful if you are watching us later on YouTube or listening to us on various podcasts or reading our publications. We hope you continue to join in future to our IMPRI Web Policy Talk and Web Policy Learning. Wishing you a good day. Thank you.
Thank you, Ritika, for conducting the sessions with Vibhuti.
Okay, Shalvi ji has raised hand. Shalvi, you want to add anything?
I just had a quick question. I am on the verge of doing a plagiarism check for my research, but I don't have access to Turnitin because that
But
is.
you have free Turnitin. No, free Turnitin.
I
for your
will
project.
check to that. If I face an issue, I will write an email to IMPRI.
Yeah.
Okay, ma'am.
Today also I shared with one of the participants. Free Turnitin link. Yeah. You will have to do page wise. Yeah.
Okay. Thank you, everyone.
Thank you.